In this video, we're going to explore expert determination, a specialist form of alternative dispute resolution which is used widely in construction and property. We'll look specifically at the role of the building surveyor as the appointed expert, how the process works, and the advantages and disadvantages compared to other ADR methods like mediation, adjudication, and arbitration. Expert determination is a private, contractually agreed method of resolving disputes by appointing an independent expert to make a decision. Unlike courtroom litigation or even arbitration, expert determination is not governed by complex procedural rules. Instead, the expert's authority comes directly from the agreement between the parties. This process is particularly suited to disputes where technical matters are more important than legal interpretation. For example, determining the cause of a defect, establishing the reasonable cost of repairs, clarifying measurement or boundary issues, or evaluating workmanship. Because these matters rely on specialist knowledge, the appointment of a building surveyor provides practical, informed judgment rather than purely legal reasoning. Building surveyors bring not only qualifications but extensive hands-on experience with buildings, construction methodology, regulations and diagnostics. Their technical background allows them to identify and analyse defects, review and interpret plans and specifications and records, assess workmanship against industry standards, or estimate reasonable costs based on recognised methods. They can also provide authoritative views on compliance and best practice. These skills make building surveyors especially valuable where the dispute depends on understanding real-world construction issues. Instead of relying on multiple expert witnesses, the decision maker themselves is the expert, simplifying and streamlining the entire process. Although expert determination is flexible, it generally follows a recognisable sequence of steps. Firstly, there's the agreement to use expert determination. The starting point is an agreement, either a clause in the original contract or a separate agreement made after the dispute arises. It's important for the parties or agreement to define the issues the expert is to determine, whether the determination will be binding, the expert powers and responsibilities, and the timetable and procedures, and most importantly, how fees will be shared. Clear scoping is essential because the expert must stay strictly within the authority given to them by the parties. Then there's the appointment of the building surveyor. The parties either agree on a suitable surveyor or they can ask a professional body such as the RICS to nominate one. The chosen expert must be independent, impartial and technically competent in the subject matter. They formalise the appointment with terms of engagement and outline the procedure they intend to follow. Thirdly, it's important to define the issues. A key early step is confirming the exact questions the expert must answer. These may include: does a defect exist and what is the cause? What is the reasonable cost of the proposed remedial works? Has the contractor met the required standard of workmanship? How should a boundary be interpreted from the available evidence? Once defined, the expert cannot go beyond these questions. Clarity here prevents future challenges or misunderstandings. Fourthly, we gather the evidence and the submissions. Both parties submit their evidence. This might include things such as plans, drawings and specifications, site photographs or inspection reports. They might also include communications between the contractor, the client or consultants, schedules of work or valuations, technical reports and previous expert opinions. The expert has the flexibility to request additional documentation, ask questions or seek clarification from either party. Then we might have site visits or technical investigations. One of the strengths of appointing a building surveyor is their ability to assess the physical issues directly, but the expert may need to inspect the building or land, take their own measurements or photos, or use diagnostic tools to identify defects. They'll do this to review workmanship alongside specifications, compare completed work to industry standards, and this hands-on approach leads to decisions which are grounded in practical reality rather than abstract argument. Then we have analysis and the decision-making process. Using their professional judgment, industry knowledge and technical training, the independent expert analyses all the information. They are not bound by the strict evidential rules of court or arbitration, and this allows them to reach a practical, reasoned conclusion more efficiently. Then we have issuing the determination. The expert issues a written determination addressing each question clearly. If binding, it is final with limited grounds for challenge. If non-binding, it still provides a strong basis for settlement or further negotiation. So what are the advantages of expert determination? Well, firstly, there's technical expertise. The greatest strength is the expert's specialist knowledge. Building surveyors understand construction better than most legally trained decision makers, resulting in a more reliable and informed decision. Secondly, there's speed and efficiency. Because there isn't formal hearings or procedural steps, the expert determination is usually faster than arbitration or litigation. Many disputes are resolved within weeks instead of months. Thirdly, it's more cost effective. Because the process is more simplified, there's a reduced need for lawyers or multiple expert witnesses, typically making it one of the most economical ADR options. Fourthly, it's more flexible. The parties control the process, evidence can be informal, timetables can be tight, and the procedure can be tailored to the dispute's needs. Number 5 is confidentiality. The process is private, protecting commercial relationships and reputations. 6th, it is final. For binding determinations, the outcome is decisive and delivers certainty, which can be particularly valuable in ongoing construction relationships. So what are the disadvantages of expert determination? Well, despite its strengths, expert determination does have limitations. Firstly is the limited ability to appeal. Because the process is designed for finality, errors, unless they are serious or procedural, are difficult to challenge. Courts rarely overturn determinations unless the expert has exceeded their authority. Secondly, it's not suitable for legal or multi-party disputes. If the dispute turns on legal interpretation or involves many parties, processes like arbitration or litigation may be more appropriate. Thirdly, the quality depends on the expert. Choosing the wrong expert can lead to flawed outcomes. The entire process hinges on the skill and the impartiality of the building surveyor. Fourthly, there's less procedural protection. The informal nature of the process can be uncomfortable for parties who want structured, evidential rules. Number 5, enforcement is contractual. While binding determinations can be enforced, they don't carry the same statutory weight as arbitration awards or court judgments. Expert determination led by a building surveyor is a powerful tool for resolving technical construction disputes quickly, efficiently and cost effectively. While not appropriate for every situation, it excels when the issues are technical and when the parties value speed, expertise and confidentiality. With careful planning and expert selection, it can be one of the most effective forms of ADR available. At Harrison Clarke, we can assist in dispute resolution, including expert determination. For more content or to make contact with us, head over to our website at harrisonclarke.co.uk.